Okay, and we are live today. Welcome, everybody. We're happy to have you here. Today, we are going to go over Volume 6 Fiduciary Process and Default Remedies. How fiduciaries structure, process, enforce defaults, and preserve estate rights. Disclaimer and legal notice. This publication is provided for educational and informational purposes only. It does not constitute legal, tax, financial, or accounting advice, nor should it be relied upon as a substitute for professional counsel. The material presented herein reflects private research, historical references, and educational analysis, including interpretations and expansions of teachings attributed to Patrick Devine as developed and contextualized by Private Path. Any references to law, equity, fiduciary practice, trusts, or administrative processes are offered solely for study and discussion, not as instruction to engage in any specific legal or financial action. Bear with me. I think somebody's trying to come in. Okay, good. All right. By accessing or using this material, you acknowledge and agree that you are acting in your private capacity, not under public advisement or representation. You assume full responsibility for your own decisions, filings, communications, and actions. No outcomes, remedies, or results are promised or implied. Private Path HR Solution, PMA, makes no guarantees, express or implied. For matters involving legal rights, tax obligations, or financial decisions, you are advised to consult with a licensed professional in your jurisdiction who is competent to advise on those matters. Bear with me. All right. And the next page. Private Membership Association PMA notice. I let her in and she didn't come in. I wonder what happened. This ebook is a private membership educational resource and the exclusive property of Private Path HR Solutions PMA, a private membership association. Access to and use of this publication is strictly limited to authorized members of the PMA and is governed by the terms, agreements, customs, and protections of private membership law. Use of this material outside the scope of PMA jurisdiction, including but not limited to public distribution, publication, reproduction, or reliance by non-members, is expressly prohibited without prior written authorization. PMA usage, confidentiality, and fee notice. Unauthorized sharing, forwarding, copying, reproduction, or provision of access to this material, whether in whole or in part, to any non-member constitutes a breach of the private membership agreement. Such breach may result in immediate termination of membership, revocation of access to PMA resources, enforcement of applicable private remedies, assessment of contractual fees or damages as outlined in PMA agreements. This resource is issued in confidence for the private education of members only and remains protected under private contract and association law. Enforcement use restrictions and administrative remedies. This publication is a private educational resource issued exclusively to authorized members of Private Path HR Solutions PMA. Access to and use of this material is conditional upon continued compliance with the private membership agreement and all applicable PMA rules, policies, and customs. If this material is found in the possession of a non-member or if unauthorized access, sharing, duplication, or distribution is discovered, the member responsible shall be deemed in material breach of their private membership agreement. Upon such breach, the PMA may impose one or more private administrative remedies, including but not limited to suspension or termination of membership privileges, revocation of access to PMA educational resources and services, assessment of reasonable administrative fees, and pursuit of all available contractual and equitable remedies. All remedies may be applied individually or cumulatively at the sole discretion of the PMA. Recording, capture, and replication prohibition. The use of audio recording, video recording, screen capture, transcription tools, note replication systems, or any other method intended to preserve, reproduce, or redistribute this material outside authorized PMA use is strictly prohibited unless expressly authorized in writing. Any unauthorized recording, capture, or replication constitutes a separate and independent breach, subject to administrative action and enforcement under the private membership agreement. Reservation of rights. Nothing in this notice shall be construed as a waiver or limitation of the PMA's rights to enforce its agreement, protect its intellectual property, or seek appropriate relief through private contractual, equitable, or civil remedies. Acknowledgement of agreement. By accessing, viewing, or using this material, you acknowledge that you have read, understood, and agreed to be bound by these terms as a condition of membership under the protections and jurisdiction of private contract and association law. And if you need to contact us, if you have any questions or require guidance or wish to access additional educational tools, classes, or consulting resources, you can visit our website at www.privatepathhrsolutions.com. For general email, our privatepathhrsolutions@gmail.com. And if you'd like to be part of the classes or educational support, you can visit at classes@privatepathhrsolutions.com. You can also visit us on Instagram or TikTok at privatepathhr. And private membership access available through our website. And we will go ahead and move forward. The material under the protections of private membership association law and is used solely for the private members' use. I need to fix that one. Sorry, guys. All right, so let's get started. We have our introduction to this volume. Once a fiduciary has asserted estate claims and established authority, as covered in Volume 5, the next step is to design and execute the processes that govern estate administration. Patrick Devine emphasized that remedy is not secured by argument or personality, but by process, notice, and record. A fiduciary must therefore function as both administrator of process, ensuring every claim, notice, and response is properly issued, tracked, and documented. Custodian of remedy, enforcing defaults when obligations go unmet without overstepping authority or risking personal liability. This volume focuses on 1. Building process protocols for estate administration. 2. Managing notices and responses systematically. 3. Applying default remedies when claimants fail to respond, comply, or perform. 4. Preserving fiduciary immunity by acting only in office capacity and documenting limits of authority. And 5. Escalating unresolved matters into equity courts only when private defaults are fully documented. Patrick Devine called this the silent power of the fiduciary, the ability to enforce rights and claims through quiet administration diligence rather than conflict. What this volume covers. In Chapter 1, we discuss fiduciary process design. Chapter 2, notice management and response tracking. Chapter 3, default remedies, principles, and procedures. Chapter 4, record keeping as evidence of authority. Chapter 5, administrative defaults versus judicial enforcement. Chapter 6, escalation protocols, when to enter equity. Chapter 7, your templates and notices, default claims, and process logs. And then you'll have your conclusion, remedy through process, not conflict. This volume arms the fiduciary with the systems and remedies needed to manage estate matters efficiently, enforce defaults lawfully, and continue Patrick Devine's legacy of private process mastery. Note on Patrick Devine's 7-part series, this volume of the Fiduciary Authority series builds directly on the foundation laid out in Patrick Devine's 7-part Private Reclamation series. Those teachings establish the essentials of status correction, trust formation, and secured party processes. The Fiduciary Authority series is not a replacement for that work, but a continuation of it, showing how to function as a fiduciary after completing Patrick's original steps. Readers who have not yet studied Patrick Devine's series are encouraged to do so first, as this material assumes familiarity with his methods and principles. Part 1, Foundations of Fiduciary Process. Chapter 1, Fiduciary Process Design. Why process matters. Patrick Devine often repeated, the record is the remedy and the process is the shield. For fiduciaries, success is not about clever arguments or court appearances. It is about structuring a process that clearly defines or clearly establishes authority, provides notice to all parties, tracks responses and deadlines, and creates a self-authenticating record for enforcement. Without process, the fiduciary risks confusion, missed timelines, or exposure to unnecessary liability. With process, the fiduciary preserves order, authority, and remedy. Core elements of fiduciary process. Number 1, your notice framework. Every action begins with notice to beneficiaries, creditors, third parties, or courts if necessary. And notices should be consistent, structured, and issued under fiduciary capacity only. Number 2, response management. Each notice requires a calendar entry and response deadline, and failure to respond triggers default remedies. Number 3, record keeping. All notices, responses, and follow-ups must be logged in a fiduciary ledger. This ledger serves as proof of compliance and authority. And number 4, default and escalation path. A clear sequence. You have your notice, opportunity to respond, default, and enforcement. And this protects the fiduciary from accusations of acting prematurely or unfairly. Designing a private fiduciary process. A fiduciary process should be repeatable, usable for every type of claim or estate issue, defensible, backed by written record and sworn affidavits. And private first. Escalation to public or equity courts only after private defaults are fully documented. Patrick Devine referred to this as laying the tracks before the train moves. The fiduciary builds the administrative structure in advance, so every action runs on rails. Tools for process design: your notice templates, pre-drafted forms for common scenarios. A response log. This is a ledger with deadlines and outcomes. Affidavit of mailings or service, your proof that notices were properly issued. Default affidavit is a sworn declaration that no response was received in time. And then you have your escalation matrix, a chart outlining when to move from private to judicial remedy. Your key takeaways: the fiduciary process is not optional. It is the framework that preserves authority and prevents liability. Every step should be documented, logged, and repeatable. Private process always precedes public enforcement. And with process in place, the fiduciary's authority is clear, defensible, and immune from personal challenge. Chapter 2. Sorry, guys. Notice management and response tracking. Why notice matters. Patrick Devine emphasized that notice is the foundation of remedy. Without notice, no party can be held to account, and without proof of notice, the fiduciary's authority may be challenged. A proper notice system ensures transparency to all parties are informed of their rights and duties. Accountability. The claimants are given a chance to respond before default. And record creation. Proof of notice becomes evidence if enforcement is required. No notice, no default, no default, no remedy. By Patrick Devine. The notice cycle. The fiduciary notice process follows a structured cycle. Number 1, your issuance of notice, delivered by certified mail, private courier, or other verifiable means, and always signed in the fiduciary capacity. Your response window, number 2. Standard is the 10 to 30 days, depending on matter and urgency, and must be clearly stated in the notice. Number 3, tracking and logging. Your date of mailing or delivery logged in the fiduciary ledger, and response deadlines calculated and calendared. Number 4, follow-up. If no response, a second notice or conditional acceptance is sent, and failure to respond after this step triggers default remedies. Response tracking. A fiduciary must maintain meticulous records of all responses, including the date received, who responded and in what capacity, substance of the response, acceptance, objection, conditional reply, or silence. The next action required by fiduciary is this creates a response trail that shows good faith and adherence to due process. Practical tools. You will have Okay, sorry about that, guys. Notice log, ledger with columns, notice number, date sent, party, response due, response received, and action taken. Your mailing affidavit is a sworn statement verifying notice was sent properly. and conditional acceptance form, standard reply when responses are incomplete or defective, and your deadline calendar. It's essential to avoid missing dates that would weaken fiduciary enforcement. Default through silence. In Patrick Devine's system, silence is acquiescence. When proper notice has been given, if the fiduciary issues notice, documents service, and tracks the response window, failure to reply constitutes tacit agreement or default. This is the power of notice management. It transforms silence into lawful remedy. Your key takeaways: notice establishes jurisdiction and authority of the fiduciary. Every notice must be tracked, logged, and archived. Response tracking prevents confusion and strengthens enforcement. Silence, when properly documented, becomes default and remedy. By mastering notice management, the fiduciary ensures every estate action is transparent, defensible, and enforceable. Part 2, Default Enforcement Principles. You guys give me 1 second. I want to make sure we're not going. It said something about changing, but I don't know where. So we'll leave that. This is all going to be new. All right, Part 2, Default Enforcement Principles. Chapter 3, Default Remedies, Principles and Procedures. Understanding default. In the fiduciary context, default occurs when a party fails to respond, comply, or perform after proper notice has been issued. Patrick Devine emphasized, default is not punishment, it is recognition of inaction. Default remedies allow the fiduciary to protect estate assets, assert claims lawfully, preserve authority and immunity, and avoid unnecessary escalation to public courts. Silence constitutes administrative default for record and remedy purposes, but does not itself constitute final adjudication absent settlement or equity confirmation. Core principles of default remedies. Number 1, notice precedes default. Proper service of notice is mandatory. Default cannot be claimed without documented notice and response window. Number 2, documentation is essential. Each step, notice, response deadline, attempts to communicate must be logged in the fiduciary ledger. And affidavits of mailing or service serve as proof if challenged. Number 3, fiduciary capacity only. All default actions must be executed in office capacity, never personally, and use such language as fiduciary for the estate of the trust name. And estate or trust name, I apologize. Number 4, proportional remedies. Remedies should match the nature and scope of default. Examples: lien filings, conditional offsets, asset holds, or administrative claims. Common default remedies. A private lien or UCC-1 filing secures estate interest against non-responding parties. Conditional acceptance of obligations ensures estate only accepts claims that are verified and lawful. Administrative offset applies against accounts, assets, or funds when obligations remain unmet. And notice of default, formal declaration that the estate will enforce remedy if the party continues to ignore obligations. Step-by-step default procedure. Number 1, issue first notice with clear instructions and deadline. Number 2, record notice in the fiduciary ledger and proof of delivery. Number 3, wait for the response window to expire. Number 4, if no response, issue notice of default or conditional acceptance. And number 5, file or initiate default remedy, a lien, offset, or administrative hold. And the last one, 6, maintain documentation for potential escalation to equity court if necessary. Patrick Devine emphasized, every step is recorded, every remedy is defensible. Best practices. Never skip steps. Notice, tracking, and conditional acceptance. Document every interaction. Silence is only default if properly proven. Maintain proportionality. Remedies should match the inaction, not exceed it. And escalate strategically. Public intervention is last. Private remedies first. Your key takeaways. Default is triggered only after proper notice and response period. Fiduciaries maintain authority and immunity by acting solely in office capacity. Remedies are lawful, proportional, and documented. And proper default management prevents disputes and strengthens fiduciary enforcement. Chapter 4, Record Keeping as Evidence of Authority. Why record keeping matters. Patrick Devine consistently emphasized the record is the remedy. For fiduciaries, record keeping is not optional. It is the foundation of all authority, enforcement, and default remedies. Proper records validate fiduciary action, proof notice and response timelines, document defaults and remedies, and protect against challenges in public or equity courts. Without a clear record, even the most lawful actions can be questioned or nullified. Core components of fiduciary records. Number 1, fiduciary ledger. Chronological log of all notices, responses, deadlines, and actions. Columns may include the date, party, type of notice, response deadline, response received, and action taken. Number 2, notice and mailing affidavits. Proof that notices were properly issued and delivered. Essential for asserting default remedies lawfully. Number 3, conditional acceptance record. Document any conditional responses to claims or demands and ensure the estate only acknowledges verified obligations. Number 4, asset and claims log. Track estate assets, claims, offsets, and payments, and supports both administrative enforcement and eventual public filings if needed. And 5, supporting documentation. Copies of contracts, agreements, beneficiary acknowledgments, and any communication related to fiduciary claims. Best practice in record keeping. Immediate recording. Enter each notice, response, and action as soon as it occurs. Chronological order. Keep logs sequential to create a clear timeline. Private ledger maintenance. Maintain records in a private fiduciary ledger separate from personal files. Backups. Keep multiple copies of all documents to prevent loss. Sworn statements. Use affidavits to verify the accuracy of logs and notices. Record keeping and enforcement. Patrick Devine emphasized when the record is complete, the estate enforces itself. Administrative enforcement relies entirely on documented notices, responses, and default timelines. Equity courts require a complete record to validate fiduciary authority and remedy claims. Every step, from initial notice to final default remedy, must be traceable in the ledger. Key takeaways: proper record keeping is the backbone of fiduciary authority and enforcement. Logs, affidavits, and ledgers establish lawful basis for administrative and judicial remedies. Timely, complete, and accurate documentation prevents disputes and preserves immunity. And following this process ensures the fiduciary's office is recognized, respected, and protected. Part 3: Escalating and Enforcement. Chapter 5: Administrative Defaults versus Judicial Enforcement. Understanding the difference. Patrick Devine emphasized that private process comes first, public intervention last. Administrative defaults. Remedies executed within the private system, notices, conditional acceptances, offsets, liens, and record-backed actions. Judicial enforcement. Remedies pursued through equity or public courts after private remedies have been fully documented and defaulted. The key principle: the estate enforces itself first. Courts validate only after proper private process. Administrative defaults. The purpose: resolves obligations and protect estate assets without public exposure. Common administrative remedies. Number 1, notice of default, the formal statement that the party has failed to respond. 2, conditional acceptance of claims, ensures estate recognizes only verified obligations. 3, private offsets, applying estate assets to satisfy unfulfilled obligations. Number 4, UCC filings, securing estate interests against non-responding parties. And 5, asset holds or liens, lawful actions to protect estate property. The benefits: maintains privacy and office integrity. It preserves fiduciary immunity and minimizes conflict and public scrutiny. Judicial enforcement. When administrative defaults fail or are ignored, fiduciaries may escalate to equity courts. Provides binding legal authority to enforce estate rights. Confirms fiduciary authority and compensation, and enables remedies unavailable in private administration, such as injunctions or forced compliance. The requirements for judicial enforcement. 1, you have a complete private record of notices and defaults. 2, your proof that administrative remedies were exhausted. 3, a clear demonstration of fiduciary capacity. And 4, documentation of all estate processes and compliance attempts. Patrick Devine emphasized equity honors the record. The man in office is recognized, not the man in the street. Choosing the right path. Rule of thumb: always attempt administrative resolution first. Escalate to courts only when all private remedies are exhausted. And document everything: notice logs, conditional acceptances, and default actions. This ensures fiduciary authority is preserved, defensible, and immune from personal liability. Key takeaways: Administrative defaults protect estate assets privately and efficiently. Judicial enforcement is a last resort, fully supported by documentation. Properly documented administrative remedies create a foundation of authority recognized in equity courts. Following this hierarchy safeguards office integrity and personal immunity. Chapter 6, Escalation Protocols, When to Enter Equity. The Fiduciary's Dilemma. One of the greatest challenges Patrick Devine highlighted was knowing when to remain private and when to step into equity jurisdiction. Entering court prematurely can jeopardize private remedies, invite joinder into the public system, and create unnecessary exposure to liability. At the same time, failing to escalate when administrative remedies are exhausted can weaken fiduciary authority and risk loss of estate assets. Escalation triggers. A fiduciary should consider entering equity only when: number 1, exhaustion of administrative remedies. All notices, conditional acceptances, defaults, and private claims are fully documented. 2, evidence of continued trespass. The public or private parties persist in ignoring notices, seizing assets, or refusing fiduciary authority. 3, risk of asset loss or harm to beneficiaries. The estate property, income streams, or beneficiary rights are at the imminent risk. And number 4, need for enforcement beyond private capacity. Injunctions, court orders, or compelled compliance are required to protect the estate. Preparing for equity. When escalation becomes necessary, fiduciaries must bring a complete record, not an argument. Essential documentation includes your notice logs, the proof of delivery and response or non-response, affidavits of default, your sworn record of failure to rebut, conditional acceptance records showing good faith attempts to resolve privately, your trust or estate appointment papers establishing your authority, your Form 56 Notice of Fiduciary Relationship filed where necessary. Patrick Devine emphasized equity respects the record, it does not hear debate. The escalation path. Number 1, private to private, attempt resolution through notice, correspondence, and negotiation. 2, private to administrative record, secure defaults, file liens, and log unrebutted notices. Number 3, administrative to equity court, present record, not argument, for judicial enforcement. And number 4, equity to higher oversight. If lower courts fail, escalate to appellate equity or treasury functions. Protecting fiduciary immunity. Escalating must be done strictly in fiduciary capacity, never as the personal claimant. Always sign as the fiduciary or executor of the estate or trust. Avoid emotional or argumentative language. And keep filings procedural and record-based. By following this structure, fiduciaries preserve their office immunity while compelling enforcement. Key takeaways: escalation is not about emotion or argument. It is about timing and record completeness. Sorry, guys. Fiduciary must exhaust private remedies before entering equity. Courts recognize fiduciary authority when it is proven by process and record. And the goal of escalation is remedy, not conflict. Caveat: the Disappearance of equity courts. One of Patrick Devine's constant warnings was that true courts of equity are rare today. Most courts now operate under statutory, administrative, or commercial jurisdiction rather than pure equity. Equity courts historically, they existed to enforce trusts, estates, and fiduciary matters outside the rigid rules of law. Today's reality, many courts are merged, law and equity combined, with equity often treated as a secondary consideration rather than a separate jurisdiction. This creates a challenge for fiduciaries. Where do you take your record when a true equity court is unavailable? What to do in this situation? Number one, strengthen your private process first. The stronger and clearer your administrative record, the less dependent you are on finding a pure equity venue. If the record is airtight, even a statutory judge can recognize fiduciary authority. Number two, frame proceedings in equity terms. Even in merged courts, you can petition in equity and require the court to act in its equitable capacity. Example, filing under the trust or estate jurisdiction rather than general civil procedure. Number three, leverage treasury and administrative forums. Patrick Devine often suggested that treasury processes and administrative claims could function as equity-like remedies when courts fail. Filing your Form 56, notices to Treasury, and constructive trust claims preserves equity principles outside traditional courts. Number four, record and publish. If courts fail to recognize your process, publishing your record, UCC county filings, notices to agencies, maintains your fiduciary authority and secures estate interests. And remedy may come later, but the estate remains protected in the interim. Patrick Devine's perspective. Patrick emphasized, don't depend on the system to give you equity. You are the equity. When you hold the fiduciary office, courts only recognize what you already established privately. In other words, the fiduciary process itself is equity in action. Courts, when available, are simply enforcement extensions of what you've already perfected privately. Part 4, Fiduciary Toolkit. In our toolkit, you'll receive your templates, notice, default claims, and process logs. Patrick Devine's emphasis was always the record is the remedy. The fiduciary who keeps clean, documented process carries equity with them regardless of whether a formal court of equity is available. This chapter provides working templates to help fiduciaries structure their notices, track responses, and record defaults. Each tool reinforces fiduciary immunity and preserves estate remedies. So I'm not going to go over each template, but you have your model notice of fiduciary authority, which you will be able to get from your ebooks that come with the class that is provided to you tonight. You have your conditional acceptance and notice of default, and this is just to give you an idea of what your template should look like. You're going to write your own. Your affidavit of default. Then you have your response and default log. These are the things that you should have in your ledger. Your date sent, document, recipient, delivery method, response received, and default or declared. This log provides the chronological evidence of process, which Patrick emphasized is more powerful than argument in any forum. You'll also have the fiduciary versus personal capacity declaration, your notice of escalation to equity, And your keynotes, always notarize affidavits to strengthen evidentiary weight. Always track your delivery by certified mail, courier, or equivalent. Always sign in fiduciary capacity, never as the personal actor. And these templates mirror Patrick Devine's private process methods: notice, conditional acceptance, unrebutted record, affidavit of default. Conclusion: remedy through process, not conflict. In summary of Volume 6, Volume 6 has guided fiduciaries through the complete process of private enforcement and default remedies. Number 1, the fiduciary process design, establishing repeatable, defensible administrative procedures. Number 2, notice management and response tracking, how to issue notices, tracking responses, and documenting in the fiduciary ledger. Number 3, your default remedies, acting when parties fail to respond with proportional and lawful measures. Number 4, record keeping as evidence of authority, creating a chronological, verifiable record of all actions. Number 5, escalation and enforcement, moving from private administrative remedies to equity when necessary. And 6, your fiduciary toolkit that provides you with templates for notices, default claims, conditional acceptance, capacity declarations, and escalation. Patrick Devine's guiding principle is clear throughout. The record is the remedy, the process is the shield. By following the step-by-step system outlined in this volume, fiduciaries protect their office, preserve estate assets, and secure lawful remedies without conflict or unnecessary public exposure. Your key takeaways: authority is established through process, not argument. Proper notice and response tracking are critical to enforce defaults. Record keeping is the backbone of both private remedies and equity recognition. Escalation is strategic, private remedies first, courts last. And templates and logs create consistency, defensibility, and immunity. What's next? Volume 7. Next week, we go over fiduciary banking and treasury functions. We'll build on these principles, showing fiduciaries how to interface with banks, treasury, and financial institutions in a private capacity. How to handle fiduciary compensation safely. Utilize Form 56, EINs, and Treasury reporting while avoiding joinder into public employment systems. Execute administrative remedies for estate funds, and maintain equity protection while managing fiduciary banking operations. Volume 7 will provide step-by-step instructions, templates, and flowcharts to navigate the financial aspects of fiduciary office confidently, continuing Patrick Devine's legacy of private enforcement and protection. Now, if you guys would, on the YouTube Live, if you want to join our classes, you're more than welcome to. We have our next PMA class starting February 25th. We also have the Series 3, Patrick Devine's Executor in Equity, that starts on the 26th of February. And we have a new one that's starting live on YouTube on 17th of February at 5 p.m. If you want to be part of the class, please send an email to classes@privatepathhrsolutions.com. Thank you for coming tonight. Give me 1 second. We're going to shut off. I'm not sure why you can't shut it off. You see?